The federal court system in the United States is a complex network of courts that work together to hear and adjudicate the legal issues of the United States government and its citizens. Due to the structure of this court system, there are a variety of different methods and paths for resolving legal issues in the United States. In order to effectively resolve our legal issues, we have to look at the concept of jurisdiction, or the authority of a court to hear a case. Based on the structure of the federal court system, there are three different types of jurisdiction that can play a role in how a case works its way through the system. The first is the concept of exclusive jurisdiction, or the idea that a case must be heard in federal court. In the U.S. court system, specific courts are assigned exclusive jurisdiction and must be the first court to hear a case that is going to go through the federal court system. Other courts have what are known as concurrent jurisdiction, which is the ability for a case to be heard in either federal court or state court. Under these circumstances, prosecutors and citizens must effectively decide where to begin their case in either the federal or state court system. Lastly, several of the courts in the federal court system have what are known as appellate jurisdiction, or the ability of a court to hear an appeal of a case that has already been decided. If citizens wish to appeal the decision in their case, it must go to a specific court based on the structure and organization of the federal court system. Within the federal court system, we also have to understand the difference between a criminal case and a civil case. The courts in the U.S. federal court system can handle either criminal or civil cases in certain instances, and other courts actually handle both criminal and civil cases. So you can see, as we look at the structure of the federal court system, that the details of jurisdiction and of the case and legal issue itself are critical in determining how a case is going to be resolved if it has to enter the federal court system. The federal court system is created based on two sections of the Constitution. Through the Constitution and the clauses built into it, Congress was given the authority to create what are known as the inferior courts. This authority comes from two places. The first is Article 3, Section 1. Article 3, Section 1 states that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may establish from time to time. The second clause is Article 1, Section 8, Clause 9, which says Congress shall have the power to constitute tribunals inferior to the Supreme Court. Based on these two clauses, we get the structure of the federal court system and the different courts that Congress has created throughout the history of our country. As our country has evolved, and as the issues our legal system has had to deal with have evolved with it, Congress has had to create significantly more courts to handle the problems of the United States government. This chart shows you the basic structure of the federal court system. At the top of the court system, we have the Supreme Court. Based on Article 3, Section 1 of the Constitution, the Supreme Court is the superior court and most powerful court in the federal court system. They have the final say in any legal decision that reaches them, and they have the authority to overrule both the federal courts that are below them in the chart, as well as the decisions of state courts if those decisions violate the U.S. Constitution. Beneath the Supreme Court, we have what are known as the 10 inferior courts. These can be divided into two groups. The first group are known as the constitutional courts, or the Article 3 courts. They get this designation because these are the courts that handle most of the legal work of the United States government, and Article 3 of the Constitution outlines the judicial branch. These courts include the 94 district courts, the 12 circuit courts of appeals, the Court of Appeals for the Federal Circuit, and the Court of International Trade that we will look at later on in this presentation. The other group of courts that are part of the inferior court system of the United States government are known as the special courts or the Article I courts, because these are courts that Congress has created specifically to handle issues related to their powers and responsibilities within the Constitution and the United States government. These include Federal Claims Court, where citizens can sue the United States government for damages or harm that may have been done to them by the government's actions or failure to act. It includes United States Tax Court, where citizens can dispute their taxes and what they believe they should have to pay versus what the government is claiming they should have to pay. It includes the Armed Forces Court of Appeals, which is an appeals court for any U.S. service member who becomes involved in a legal issue while serving in the United States military. It includes the Court of Appeals for Veterans Claims, which is where military veterans can go to make sure their benefits and privileges that have been earned through their military service are being properly distributed to them by the United States government. And then it includes two other courts known as the Courts of Washington, D.C. and the Territorial Courts. These courts exist because Washington, D.C. and the major U.S. territories are not states and therefore do not have a state court system like Pennsylvania, New York, or any other state in the United States. Collectively, these 10 courts resolve all of the legal issues within the United States and serve as the method for citizens to have their legal disputes resolved if they are appropriate for the federal court system. The most important courts in the federal court system are the 94 district courts. These are 94 courts that are divided between the 50 states and are divided into 89 judicial districts. In addition to the 89 districts throughout the 50 states, Washington, D.C., Puerto Rico, Guam, the Virgin Islands, and the Northern Mariana Islands, which are all U.S. territories, have their own court to resolve federal issues in those states. These courts vary in the number of judges and courts within a state based on the workload of that area of the country, as you will see on the map on the next slide. If you examine this map, which is also on page 314 in your textbook, you can see the 94 district courts that are scattered throughout the United States. In less populated states, such as Wyoming or Colorado, the entire state is under one federal district court, which means any federal legal issue that occurs within that state must go to the federal district court in that state. Other states, for example, such as Texas, which have a much larger population and therefore more federal issues to deal with, are divided into multiple federal district courts. So by looking at the state of Texas, you can see its 4 district courts: the Northern District Court, the Eastern District Court, the Southern District Court, and the Western District Court. Each handles the federal legal issues within that area of Texas. Pennsylvania, our state, is divided into 3 districts. We have the Western District, the Middle or Central District, and the Eastern District. In most cases, these federal courts are located in one of the major cities within their particular district. Pennsylvania's is in Pittsburgh, Philadelphia, and Harrisburg, the 3 largest cities in our state. The 94 district courts have jurisdiction over all federal cases unless that case is assigned to a special court. So most of the legal work in the United States court system is done by the 94 district courts. They handle roughly 80% of the federal caseload, or about 350,000 cases per year. This equates to roughly 15 cases per day per court being heard and resolved throughout the United States. The federal district courts also hear both criminal and civil cases. So the majority of the legal disputes are resolved in these courts. If the decision in one of these courts is a decision that one of the parties wishes to appeal, then the case progresses to what are known as the 12 Circuit Courts of Appeals. In the 12 Circuit Courts of Appeals, the country is divided up into 12 regions or circuits. Each one of these circuits has what is known as appellate jurisdiction, which means they may hear appeals of cases that are tried anywhere within their region of the country by a lower court. As you can see from this map, the different colors and numbers represent the 12 Circuit Courts of Appeals. This orange region, which includes the states of Arkansas, Missouri, Iowa, Minnesota, North Dakota, South Dakota, and Nebraska, are all lumped together in what is known as the 8th Circuit Courts of Appeals. Any federal case that starts in a district court throughout the 8th Circuit would be appealed to the 8th Circuit Court of Appeals. So a case that starts in the Eastern District of Arkansas would go to the 8th Circuit Court of Appeals. A case that occurs anywhere in North Dakota would go to the 8th Circuit Court of Appeals. And a case that occurs anywhere in Minnesota would go to the 8th Circuit Court of Appeals if the decision in the original case was appealed by one of the parties. This structure gives the Circuit Courts of Appeals a significant amount of authority within our court system. Since most cases do not reach the Supreme Court, these judges in these circuit courts usually have the final say in most legal issues. The cases that progress from the Circuit Court of Appeals to the Supreme Court are usually cases that have a major legal issue at stake or where there was something inappropriately done by one of the lower court judges and it was not corrected by the appeals court judge. The 12 Circuit Courts of Appeals handle roughly 15 to 18% of the cases that occur throughout the country, because roughly that number of cases is appealed on a yearly basis. This results in the circuit courts hearing roughly 55,000 appeals per year. And as previously mentioned, this is the court that makes the final decision for the vast majority of cases. Less than 1% of cases will ever reach the Supreme Court due to them being resolved properly by the federal court system, either in the Circuit Court of Appeals or in the original case in the 94 District Court. In addition to the 94 District Court and 12 Circuit Courts of Appeals, there are two major constitutional courts that we also need to look at. The first is the Court of International Trade. This court exists to handle specific cases related to international trade. So issues of tariffs or international agreements and treaties that the United States have made are all handled in this court. They have original jurisdiction over these cases and not the 94 district courts or any of the other special courts. If the cases in these courts want to be appealed, they have to go to a special appeals court circuit known as the Federal Circuit Court of Appeals, which is the last court we'll be reviewing. The Court of Appeals for the Federal Circuit is essentially a national appeals court. Under certain circumstances, individual cases can be chosen to go to this court instead of going to a traditional appeals court in one of the 12 districts. This includes cases that may be of a high-profile nature due to the individuals or circumstance involved in the case. Any case where a citizen's legal issue started in a special court, such as U.S. tax court or a territorial court, those cases are appealed to this court system instead of the 12 circuit courts of appeals. And any cases that are an appeal of patent or trademark or copyright issues are heard here due to the specific nature of those cases. Collectively, the 94 district courts, the 12 circuit courts of appeals, the special courts that handle the specialized cases, and the circuit court or the Court of Appeals for the Federal Circuit resolve the legal issues in the United States in a very effective manner, making sure that the rights of citizens and the proper application of federal law is being recognized throughout the country.